The Senate Judiciary Committee hearing room buzzed with anticipation, a low hum of conversation filling the air as staffers shuffled papers and reporters adjusted their cameras. At the center of it all, Judge Sarah Mayweather sat poised at the witness table, facing her confirmation for the United States Court of Federal Claims, a pivotal moment in her legal career. Television cameras captured every nervous glance and whispered exchange, broadcasting the proceedings to a national audience eager for drama and answers. This was no routine hearing. The stakes were high and the scrutiny intense, with every detail under the microscope.
Congratulations to each of you. Judge Mayweather, you've been nominated to the Court of Federal Claims, is that right?
Yes, Senator.
How many motions have you argued in the Court of Federal Claims?
I have argued hundreds of motions involving complex civil claims in numerous courts. The Court of Federal Claims is not one of those courts.
Okay, so the answer is 0.
That is correct, Senator.
Okay, how many cases have you tried in the Court of Federal Claims?
I have tried a civil case in the District Court for the District of Columbia. Most of my cases have been resolved on motions. None of those cases have been in the Court of Federal Claims, although they involve similarly complex matters under civil laws.
So the answer is 0.
That is correct, Senator.
Senator John Kennedy of Louisiana, known for his direct and sometimes unyielding style, was ready to test her knowledge and composure. He had studied her record in detail, coming prepared to probe her understanding of the court's unique demands and to challenge her on the finer points of federal law. The hearing began with formalities and polite introductions, but the mood shifted palpably as Kennedy took the floor, his reputation preceding him. He skipped broad legal theories and went straight to the practicalities of the court's procedures, asking about specific statutes and real-world scenarios. Judge Mayweather, perhaps expecting a more philosophical debate, seemed momentarily unprepared for the barrage of technical questions. The spotlight grew even harsher as Kennedy's questions zeroed in on her readiness, pressing her to demonstrate not just knowledge, but judgment under pressure. This was more than a test of credentials. It was a public examination of competence, temperament, and the ability to withstand intense scrutiny. The outcome would soon spark a national conversation about judicial qualifications, fairness, and the standards we set for those who interpret the law.
What is the, tell me the grounds for granting a new trial in the Court of Federal Claims?
All of the trials in the Court of Federal Claims are bench trials, and the Court of Federal Claims, although it is not bound by the federal rules of civil procedure, its rules mirror those rules when applicable. So it's my understanding that the same rules that would apply in the district court are also applied in that context. But if I were presented with a motion for a new trial, should I be confirmed as a judge on the Court of Federal Claims, I would, of course, consult the rules of court of the Court of Federal Claims.
So what are the grounds for granting a new trial?
My understanding is that a new trial, you would have to comply with the applicable rules.
I know that, but what are they? What are the grounds? You said that the rules are identical to the Court of Federal Claims and Federal District Court. I'm not sure that's accurate, but just tell me what are the grounds for granting a new trial.
The room waited, tense and silent, as the first pointed questions landed, setting the tone for a hearing that would not soon be forgotten. The United States Court of Federal Claims is no ordinary court. It's where citizens and corporations sue the federal government for money damages, cases that can involve billions and affect national policy. Judges here must master complex federal statutes, tax law, and government contracts. A lack of expertise isn't a minor flaw, it's a critical weakness. The court's decisions have enormous financial and human consequences. Senator Kennedy's focus on Mayweather's experience was essential. Her state court background offered little preparation for these federal challenges. The Senate's job is to ensure nominees are specifically qualified, not just generally capable. Kennedy's questions weren't trivia, they were a test of her ability to handle the court's unique demands. The stakes for taxpayers and litigants could not be higher. Senator Kennedy began with a deceptively friendly tone, his Southern charm on full display as he welcomed Judge Mayweather to the witness table. But beneath the politeness, his questions were sharp, precise, and clearly designed to probe the depth of her legal knowledge. He started by asking Judge Mayweather to explain the doctrine of privity, a foundational concept in contract law that every judge should know. Her answer, however, was vague and meandering, missing the practical core of what the doctrine actually means in real-world cases.
Let me be sure, Judge, I understand your testimony. Can you tell me one single ground for granting a new trial in either a federal district court or the Court of Federal Claims, as we sit here today?
Yes, if you misapplied, if there were gross misapplication of the law, certainly a litigant would argue for
Anything
a
else?
trial.
There are like 6 or 7 of them. Can you tell me any others?
Trials are so infrequent in the civil context, and although I have presided over bench trials and a jury trial, I have not been presented with a motion to have a new trial.
Okay.
Kennedy didn't pause. He moved on. "What's the Contract Disputes Act?" he asked, his tone still measured but insistent. Again, her response was general, lacking any specifics about the Act's procedures or its significance in federal contract law. He pressed further. Could she outline the Tucker Act's main components? She hesitated, unable to provide a clear answer.
Okay. What's a contract of adhesion?
A contract,
Excuse me.
Senator, I'm familiar with contract law, the concept of contracts of adhesion.
Yeah, you're going to say a lot of that. That's what Court of Federal Claims does. What's a contract of adhesion?
Senator, the Court of Federal Claims does handle a lot of procurement cases. Those typically turn on interpretations.
Yes, ma'am, but I'm going to run out of time. What's a contract of adhesion? If you don't know, just tell me.
Senator, despite my extensive civil experience, including dozens of cases that include contract cases, I have not dealt with the question of what a contract of adhesion is, but should it be presented to me, I would.
You'll look at it.
When asked about the difference between termination for convenience and termination for default in government contracts, her answer was muddled and confusing, revealing uncertainty. Each question exposed a new gap in her knowledge, making it clear she was struggling with the basics. Kennedy's approach remained calm and professional. Public trust in the judiciary depends on both impartiality and competence. When a nominee can't answer basic questions, that trust is shaken. The risks are real. A judge unfamiliar with contract law could mismanage billion-dollar cases. A misunderstanding of veterans' claims could deny rightful benefits. These aren't abstract errors. They have real financial and human costs. Mayweather's knowledge gaps previewed the potential harm of her confirmation. Her controversial rulings, especially on public safety, raised alarms about her temperament. The Senate's advice and consent process is a vital safeguard. Kennedy's questions weren't personal. They were about protecting the public. The hearing forced a necessary debate about what we should demand from our judges. Trust in the judiciary is earned through demonstrated competence, not promises to learn on the job. The Mayweather hearing was a stark reminder of the Senate's duty to ensure a qualified judiciary. Kennedy's tough questions revealed a nominee unprepared for the court's demands. Judicial appointments require more than a good resume. They demand proven expertise and sound judgment. Confirming someone with obvious gaps is an unacceptable risk to the public. The Senate's gatekeeping role is essential to maintaining trust in the courts. The hearing showed the system working, exposing weaknesses, prompting debate, and demanding accountability. The judiciary must be insulated from politics but never from scrutiny. Only those who have proven their worth should be entrusted with a lifetime on the bench. Kennedy then turned to Mayweather's judicial record, highlighting troubling reversals by higher courts. In City of Northwood v. Development Group, she allowed a developer to bypass environmental rules, a decision unanimously overturned for ignoring legislative intent. Another case saw her dismiss a small business's claim over a missed deadline, only to be reversed for being unnecessarily rigid. These weren't minor errors, they had real-world consequences, potential environmental harm, and financial ruin for a small business. Kennedy's point was clear. Her judgment was not just occasionally flawed, but consistently questionable. If she made such mistakes in state court, what would happen with the complex cases of the federal claims court? The pattern suggested a lack of practical wisdom, not just legal knowledge. The committee saw a nominee whose decisions had already caused harm. The risk of greater mistakes at the federal level loomed large.